afternoon, everybody. Nate Eaton coming to you live in our studio in Idaho Falls. It is 4 o'clock Mountain Time. It's been a while since we've done a Courtroom Insider. Thought we'd jump on here this afternoon, though, and recap what happened this morning during Chad Daybell's hearing. It was quite a hearing. There was a lot that was discussed. The big motion that came, the only motion really that came before Judge Boyce today, was a motion filed by the by the defense, John Pryor, that he wanted off the case. And he filed this last week, less than 3 months before the trial. And he said, I basically want off the case. Before we get going, though, I want to be sure that we are live. So if you are watching, let us know where you're watching from. And if you have any questions, we're happy to answer those. We have a busy afternoon here at East Idaho News, just so you know. A Reed's Dairy is on fire, which is a really popular dairy. If you're from the area, you know. It's not their main store, but their processing plant next door. So there's firefighters on the scene there. So there's been a lot of news. Okay, so the motion filed last week, John Pryor filed a motion that said, I need to be off the case because my client can no longer pay me. And there's a lot of work to do between now and the trial. And even if I worked 24/7, I couldn't get it all done. And because of that, Judge, I need to be off the case. Now, you will recall that last year, John Pryor filed a motion saying that and actually argued in front of Judge Boyce that he was awaiting some DNA evidence from the prosecutor. And because of that, because he did not have that evidence and he wanted it tested, he needed Chad's trial delayed. And the judge granted that. So Chad didn't go to trial last spring with his wife, with Lori. It was delayed a whole year so that he could do the DNA testing. But the DNA testing never happened. After the trial, John Pryor said, I no longer am going to do the testing on this DNA. So this now happens, and the prosecutor said today, this seems like a veiled motion to try to get the court to push off the trial yet again. Pryor has represented Chad pretty much since the beginning. It's been a death penalty case from the beginning. He's known about Chad's financial situation from the beginning. It's not like Chad, lost his job last week. So the main reasons that John Pryor listed in his motion filed last week were Chad can no longer pay me. I'd have to work night and day and I still wouldn't be ready for the trial. And I am not death penalty qualified as an attorney. And I can't find co-counsel who are death penalty qualified. It is true. I think there are 33 or 36 attorneys in the entire state that are death penalty qualified. A lot of them are tied up. In case you haven't heard, there's been a lot of serious crimes in Idaho lately. There's a few appointed to the Koberger case. Jim Archibald and John Thomas were appointed to Lori's case. They can't take on Chad because of the conspiracy. It would be a conflict. So it is true that it is hard to find attorneys for that, that are death penalty qualified. But Judge Boyce pointed out today that if you hire a private attorney, they don't have to be death penalty qualified. You can hire whoever you want as long as you can pay them, or they do it pro bono. But if the state appoints attorneys for you and you face the death penalty, they have to be death penalty qualified. So legally, John Pryor, in the eyes of the law, because he's independently retained by Chad, he doesn't have to be death penalty qualified. But I'm kind of getting ahead of myself. So the motion was filed last week by John Pryor saying, I need off the case. He filed it under seal. Judge Boyce said it can't be filed under seal. He unsealed it so we all could know about it. And he said, this is the argument. Now, the state filed a response yesterday objecting to the motion. And then today was meant to argue the motion. I want to play some clips from the hearing today so that you can hear what happened in court. Sorry, it's Zoom cameras. They're not zoomed in, but you can hear properly. I'm going to play it. It's a little longer snippet from Pryor. And then after this, we had to leave the courtroom. There was some sealed stuff that happened. We waited in the hallway about 30-40 minutes. Then we were allowed back in. Then Lindsay Blake gave her response. Then the judge took a brief recess, and then he came in and issued his ruling. But for now, this is what Pryor said at the very beginning of the hearing. I want you to hear what he said, and I'd love to know your thoughts as he's speaking about it. Here we go.
In 7 days, a motion to seek additional counsel.
Okay, we're having that tech issue yet again. You could hear Pryor. I don't know if you could see Pryor. If you could, let me know. You should be able to see them, but we went to black. Yeah, Jordan, who always helps me out here, we went to black when I switched over. John Pryor basically kind of said both things today. He said, I want to be paid, but I don't need to be paid. But Chad really wants me on the case. You can see this is what it looks like when you switch. Chad really wants me on the case, but he knows that I need to leave the case in order to give him the best representation possible. And it was a little back and forth. If you watched it, you saw that it was a little back and forth over what exactly is he saying. Does he want to be paid or does he not want to be paid? A lot of you have asked, how is he getting paid? Well, Chad put up a significant amount of money up front to retain him. Lori Vallow did the same thing with Mark Means, her original attorney. Then Chad Daybell's attorney, John Pryor, took possession of his house in Salem. Let me see if this works. No, that one didn't quite work. We have a connection issue, we think, and we're trying to get that fixed so that we can play it for you. So that's what happened there. That's how he's getting paid. But he's saying that Chad is out of money now. So Pryor said, I want to get paid, but I don't need to get paid. But Chad Daybell thinks I should get paid. Chad Daybell wants me on the case, but the only way that I can adequately help him on this case is if you let me off the case, Your Honor. So it was kind of a little all over. And then he brought up the death penalty qualification phase. And John Pryor did say, I have been trying since last year to get somebody to come on as co-counsel with me. And I haven't been able to find anybody that can in the state. And the judge didn't doubt that. As I mentioned a second ago, there are only so many attorneys that are public, that are death penalty qualified. And then he said, I've even gone out of state. I've tried to find people out of state. And I finally found an attorney who would go through and apply. I guess you apply to be death penalty certified. By the way, this is an issue I want to look in further into an in-depth story on what does it take to be death penalty qualified and why is there such a shortage. And Pryor said this guy or this attorney that I know did apply and he's waiting to hear back and he hasn't heard back. And basically I'm fighting this case by myself and I can't make it. I can't do it. I needed a co-counsel with me. So that's what was brought up there. Okay. We might have it here. Let's see if we do. We've got it. Okay. Do you want to make that full screen? Now I'll be able to play for you what Pryor said. Thank you for bearing with the technical difficulties. This is what John Pryor said today. He's on screen right. Judge Boyce is on screen left.
Judge, I appreciate the court releasing the order from 8/25/23. The court's well aware ex parte that I filed in January of 2023, well over a year ago, a year and 7 days, a motion to seek additional counsel. And the court identified the fact that at this point, being privately retained, that Mr. Daybell may not be eligible for having additional attorneys represent him. And I'm relying on the court's interpretation of that statute. And Judge, what has transpired, and as a matter of procedural history, in middle to late of 2022, I started the process of seeking additional counsel I believe that was probably about 2 years ago. I started seeking a year and a half ago, seeking the possibility of getting additional counsel aid me in this case when I realized the magnitude of the discovery. That process involved, Judge, going through the list of qualified attorneys on the Public Defense Commission list. I took the process of identifying all of those folks and then reaching out to all of them. And the ones I didn't speak to directly, I spoke through the various public defenders, the people who ran the public defender's office. I went through that list and at that point was unable to find anybody that was available to do this. And it's no secret, it's reasonable common knowledge that the Public Defense Commission is having a difficult time finding death qualified attorneys to represent in these kind of cases. I then contacted the commission on a couple of occasions and spoke to their one of their assistants and their directors and got the idea of maybe reaching out to out-of-state attorneys and did the process of contacting about 6 out-of-state attorneys to see if that was a possibility as well. And again, with no luck. Shortly thereafter, I went through again and went through the same process, looking through the list of qualified attorneys. In January of 2023, about a year ago, I reached out to the court and said, listen, it's going to require additional counsel. Mr. Daybell is indigent. He doesn't have the ability or financial ability to hire another private counsel at this point. And the court went through its analysis and thus came up with the order that you released today, Judge. What has transpired, Judge, is that approximately in Judge, I don't want to misstate, so I want to be very careful about this, but I believe it was in October of last year, I reached out to a private attorney that I know and asked him if he would consider becoming death penalty qualified to aid me in this case, and he agreed to do that and started the process. He has been in relative contact with the Public Defense Commission. And at this point, up until today, when I spoke to him this morning, the holdup is the CLE, but that, you know, whether it's no fault of his or the Public Defense Commission, and I'm not putting any blame, but at this point, there's no appointment, there's no decision that has been made. And I'm really unclear because the commission won't tell me his status, only I can get relayed by what he's telling me. But it came to, I came to realize in late December that the amount of work that I'm going to need to perform before the trial was of such an extent that it would, in my opinion, create a situation where not all of the things that needed to be done for the trial commencing in April 1st could get done. This put me in a difficult situation. I want to relay to the court.
When you say December, what, December of this last year, 23?
December of 2023, Judge.
All right.
I realized at that point when there wasn't a decision about him being appointed, and the court obviously directed with its order that you'd be willing to compensate another attorney to help me. But in December, I contacted the attorney again. I was in relative frequent contact with him. And he said, listen, there hasn't been a decision. I said, you know, please contact them, find out what the holdup is. Where are we on this thing? And since that time, it was more than weekly that I was communicating with him. Up to today, there still hasn't been a decision. I don't know what the status is, and there hasn't been an approval. At this point, this puts me in the situation where this court, I don't think, is obligated to appoint an attorney. Mr. Daybell has private counsel. And I want to state to the court that I don't desire to get off this case. I want to stay on this case, and regardless of Mr. Daybell's financial situation, I want to stay on this case. I could care less about the money. Mr. Daybell wants me to stay on this case.
Well, that's not really what your motion says, though, Mr. Pryor. Your motion says you want off the case because it's going to cost too much for you to work, the work it's going to take to get it through trial without compensation. So
right, and that's correct, Judge.
This is an important issue for me today. Are you wanting to withdraw because you think you deserve to be paid for the work you do, which I understand, but when I'm considering the standards under Rule 44.1, which is discretionary under Part A, on a leave to withdraw, I may allow you to withdraw for good cause. And what I'm trying to determine is, do you want to withdraw because you're not being paid enough to continue through trial, or are you seeking to withdraw because you're simply not going to be prepared and ready for trial?
Judge, the situation is this, is that when I say to the court, and I'm saying that in all sincerity, I don't need to get paid for this case. The concern is this, is that at least at this perspective, Judge, I'm going to be doing this by myself. And it's going to expend a lot of resources and a lot of time that I'm not going to be able to commit to other projects or other situations. Now, obviously, I'm not taking on a lot of other obligations because of this case. Do I want to get paid? Everybody wants to get paid for what they do. Am I making that the only reason to withdraw? Well, it's twofold. Do I want to get paid for the work that I've done in this case? I do. I'd like to get compensated for the next 2.5 months and for the 2 months of the trial. And I do want to get paid, and I think it's fair. And Mr. Daybell and I had a discussion about this. Mr. Daybell expressed to me that he doesn't feel comfortable me continuing in this case if I'm not getting compensated for the work.
Okay, so there's a little bit of that. So Judge Boyce, as you could say, was like, well, clarify, do you want to get paid? Do you not want to get paid? Because in the invoice, in your motion, you filed that you wanted to get paid. And because he couldn't pay you, you wanted out. After Pryor talked a little bit more, Judge Boyce said, all right, the question I have is, are you ready for trial? Do you have a mitigation specialist? This is a capital case, a death penalty case. A mitigation specialist is someone who joins the defense team and is the advocate for the defendant. So if this person would join the team and would go out on behalf of Chad Daybell, interview his family, interview Chad, do a history, an in-depth investigation on Chad Daybell's life. They are advocating for him to stay alive, to not get the death penalty. Lori Daybell had a mitigation specialist, but when there were issues over whether the mitigation specialist could do an in-depth investigation prior to trial, that's when Judge Boyce took the death penalty off the table because they would not be ready, and Lori refused to waive her right to a speedy trial. So Judge Boyce flat out said to Pryor, do you have a mitigation specialist? And Pryor would not answer publicly. He said, I'm not going to divulge my strategy for the trial. If we want to talk about this, we can go into a sealed hearing, but I don't want to divulge on public television, on the internet, East Idaho News, what I have and what I don't and what not. So the judge granted that request, and we were all sent out of the courtroom for about 30 to 45 minutes. We had to go far enough away that we couldn't hear what was happening in the courtroom, and we waited. And then the prosecutors came out. And Judge Boyce explained after that he had ex parte communication with John Pryor and with Chad. And he asked Chad, do you want John Pryor to be your attorney? And Chad said, yes, I want him to be my attorney. But I also understand that he can no longer get paid. So after that closed hearing, it was time for the state to argue. And Lindsay Blake was arguing, Fremont County attorney, on behalf of the state. And, Lindsay flat out said, we're a little confused because what was in the written motion that John Pryor filed last week was not necessarily what he argued this morning. So they prepared their response to the written brief, but not what he said this morning. But I'm going to play a little bit about a little bit of what Lindsay Blake said today in her response. And, basically her argument about why.
Lays out that a trial court's failure to conduct an inquiry into any conflict may result in a reversal of a conviction down the road. Additionally, the owner is on an attorney seeking to withdraw to present sufficient facts to support the motion. And from the state's perspective, we are a little confused today because we read the affidavit that was presented to the court. Most of our motion was in response to that. The court has in fact done the inquiry and answered most of the questions the state had, also unsealing the order from the January proceeding where the defendant had referenced that Mr. Daybell was found indigent. We now have reviewed the transcript of that, and that did answer some of the state's additional questions, one being that there was an actual finding of indigency. The reason that that's so important in this case is because the Idaho criminal rules outline if someone is charged with a capital offense and they're found to be indigent, I think the term they use is needy, but the equivalent, and they choose to hire counsel, they're allowed to do that. They can have private counsel of their choosing. However, if they opt to request the court appoint counsel, then there's certain requirements, and that includes having a capital qualified first chair attorney and a capital qualified second chair attorney to assist them in the proceedings. In addition to that, it flags some additional requirements that the public defenders have to comply with. And there are quite a few of them in that list that must be complied with. But again, if a defendant opts to have private counsel, I think they do so knowing that their private counsel would not have to comply with those, or at least their counsel should be advising them of that. But they could also choose to forego having private counsel once they're found indigent in order to allow capital qualified attorneys to be appointed. In the review of the proceedings from back in January, it appears that there was a request to have some additional counsel assist on the case, and that was made by Mr. Pryor with his client, Mr. Daybell, present. At that juncture, it looks like Mr. Pryor was advised that if he could find someone else to assist in the case, that there may be funds available to help pay for that second attorney. In later proceedings, it looks like the court revisited that issue when no other attorney made an appearance. And at some point in those proceedings, Mr. Daybell was asked and essentially waived his right to have capital qualified attorneys. He opted to stick with Mr. Pryor. What's frustrating for the state is back in January a year ago, both the defendant and Mr. Pryor were aware of the defendant's financial situation. They clearly presented it to the court for the finding of indigency. At that juncture, they also were well aware that there was no second chair helping on this matter. So here we are a year later, and for the first time, this issue is being brought up that, hey, I actually want to withdraw because I'm not going to get paid. I'd have to work 24/7 in order to be prepared for trial and still probably can't get everything done in time for trial. So we've got two issues within that motion. One, the not getting paid, and the second one, whether or not Mr. Pryor can be prepared for trial. The state tries to be cautious in interjecting ourselves too much when it comes to a defendant and their choice of counsel. However, I think the ethical rules and other rules mandate that prosecutors try to ensure that defendants have the right or are advised and actually have counsel representing them in proceedings. When we look at that requirement of the state, as well as some of the other factors the state has to consider, such as appellate issues, the state tries to be cognizant of those and do our best to avoid creating them. I think that's what the court has indicated here today. The real question is, at least for the state, the finances the state's staying out of, but the real question for the state is, can Mr. Pryor be effective at trial? The state doesn't want to redo a trial. We don't want to get through trial and then have an appellate issue that requires us to do that again. While the state is extremely frustrated that this is being filed so late, and we are frustrated for the citizens, we're frustrated for the victims in this case. If this motion's granted, the state fully recognizes it's going to cause a pretty significant delay. And now the victims' families have to wait that much longer. The state now has to absorb additional costs. It's frustrating, but in looking at the big picture, we also want to ensure that we don't have counsel that cannot be adequately prepared for trial. When I said the state was a little confused today, the reason for that confusion is I'm referencing what was said in the motion. What's been presented here in court today is very different. So we have conflicting statements from defense counsel at this point. The motion read as if counsel was indicating, I cannot be effective. If you make me stay on this case, I cannot be effective. The reason I say that is no person can work 24/7 on something. We all have to have time to sleep. We have to have time to do other things. So I know it's a phrase used a lot, but the reality is if working 24/7, Mr. Pryor cannot be prepared for trial, what he's indicating is he would be ineffective at trial. What he's presented today is no, I can be effective. The motion says I'm not going to get paid. I want off the case. Today what's being presented is no, I'm fine not getting paid. I'll stay on the case. So if Mr. Pryor's representations today are I'm okay not getting paid and I can be effective, I don't actually know why we're here today. This doesn't appear to be a true motion to withdraw. The concern for the state is we've had multiple continuances in this case, and I recognize there can be arguments back and forth as to who did what and who caused the continuance. But at the end of the day, a year ago, Mr. Pryor was fighting very hard to get a continuance. He filed multiple motions to get a severance. He was finally successful with those in January, around January of last year. Maybe it was February, but he ended up getting both a severance and a continuance. Got a year-long continuance. Again, last January, Mr. Daybell had been found indigent. They knew there wasn't a second chair. He's proceeded on the case for a year. He had the benefit of watching the co-defendant's trial. He knew exactly how long that trial was, was able to observe and see how many witnesses there were, should have had a very good idea of what the trial preparation was going to require at that juncture. So again, very frustrated that we're getting here, but we had that. The request was, I need a continuance to test the DNA. We get past the trial. I'm actually not going to test the DNA. The state recognizes that different tactical decisions can be made, but it was very frustrating that we ended up with a continuance and severance for something that never ended up getting tested. Now.
Okay, so that is what Lindsay Blake said, that basically a year ago, nothing's new. Nothing's new. That we got the trial severed because he wanted to test the DNA that he ended up not testing. He got to sit through the co-defendant's trial. We knew he was indigent back then. The death penalty was on the table back then. In his motion that he wrote, he said he was saying that his client didn't have any more money, but today he's saying it's not about money. So she said, basically, this is a veiled motion that he wants it continued, or he's ineffective counsel. Now, Pryor shot back at that and said, I've never said I'm ineffective counsel. I am effective, and my client believes that I am effective. And then Lindsay responded that, we weren't saying you were ineffective. We're saying, are you going to be prepared for trial? Because if not, you would be ineffective. Here's the thing. All Chad Daybell had to do was say, I want a new attorney. My attorney can't represent me. I want a death penalty qualified attorney. That's really all he would have had to do, in my opinion, for the judge to say, okay, I got to give it to him. And then his attorney to back him up and say, I can't. He wants a death penalty qualified attorney. I'm not that. He needs someone else, and clearly he wants someone else. But he didn't. Chad Daybell kept saying, I want John Pryor as my attorney. So that's where it ended up. The judge basically said, I'm going to take a break. I got to review some things. And then he went back into his office, into his chamber. And when he came back out, he was prepared to rule. Now, he noted something, and I don't know if this might be in the clip that I play for you. If it's not, he noted something that Pryor said at a hearing last year that here, I'm going to read it to you because I don't want to try to summarize it and get it wrong. He said that John Pryor at a hearing last year said, there is going to be no continuance because I'm asking to get out of this case. That will not happen. Pryor said that a year ago, and Boyce said that to him today, to his face. Let me remind you, during a hearing a year ago, you said, there is going to be no continuance because I'm asking to get out of this case. That will not happen. And then Boyce said this.
And those guidelines may or may not be elected to be followed by a private attorney. Mr. Pryor clearly is a private attorney in this case, has never been appointed or publicly paid for representation of Mr. Daybell. Mr. Daybell, importantly, does have the right under the Sixth Amendment of the Constitution to counsel, and included in that right is to have the counsel of his choice. And Mr. Daybell elected a very long time ago to have Mr. Pryor represent him in this case. In fact, Mr. Pryor has agreed to take the case and has represented Mr. Daybell not only through the initial stages of the case here where the indictment was returned, but also in a previous companion case, and for I think about 3.5 years now, has represented Mr. Daybell. The court then going back to consideration of the motion before the court. There's an issue here that's been raised by the state about the timing, and of course the court joins in that concern also. Mr. Daybell has been incarcerated since June 9th, 2020. We've got a trial scheduled in 2 months. Mr. Daybell's asserted his right to that trial, and although he has waived his right to a speedy trial, certainly this case has taken a long time to get to trial, and at some point, even with a waiver of speedy trial, the court has to consider the timeliness of a defendant in custody being granted their opportunity for a timely trial. That right also applies to the state, and the state's right to seek justice for victims, to seek a conviction if they believe they have the evidence to do that, and to not have to wait through unnecessary and unreasonable delays in bringing a case to trial. So the court has a duty to try to timely administer cases, and while the rules generally slow things down a lot, there are reasons for that, but at some point the court has to consider the timing here. That's the big issue with this motion, quite frankly, is that the motion, if granted, would absolutely require a continuance of the trial and not just a brief continuance, because what would occur if I grant this motion and Mr. Pryor withdraws from the case, then under Criminal Rule 44.3, the court is required to appoint 2 capital qualified public defenders, absent Mr. Daybell having some manner of, again, rehiring a private new attorney or getting one to do it pro bono. The issue there is Idaho has a sparse number of attorneys on that roster, and Idaho is currently experiencing a lot of cases that are already resulting in appointments of a lot of available attorneys. And quite frankly, I don't have any idea who would be appointed of the 2. I don't have any idea when we could get them appointed. But what I do know is the trial would have to be vacated and would have to be continued, and I think likely for a long time, maybe a year, maybe even more. Because for new counsel to come in, start over from scratch on a complex case like this, not have any review of discovery or any preparation, they would have to reasonably request time to get prepared, which would have to be granted. Mr. Pryor was raising concerns about trying to get second counsel appointed, and I've tried to accommodate that, Mr. Pryor. We had a hearing, it was exactly a year ago, on January 19th of 2023, and talked about your concern. The way I interpreted Rule 44.3, while it doesn't really address a situation with a private attorney together with a public defender, I don't think the rule necessarily prohibits that either. And so I approved that you could have co-counsel if you could find someone, but of course, they would have to be on that approved roster because this is a capital case. I don't doubt that you've made a diligent effort to try to find co-counsel. That's clear to the court. I know we've addressed that over the course of the last year on numerous occasions, the status of whether or not someone was coming into the case. we're on the eve of trial and no one has come into the case. With that in mind, then, the court has to also look at the impact that could potentially have. If Mr. Pryor withdraws from the case, Mr. Daybell is required to start over, abandon an attorney-client relationship that's been ongoing for several years, start over with a brand new attorney-client relationship with someone that he doesn't know and we can't even tell him who that would be. And also with the delay, I find that that prejudices the defendant. I also would find that given all of the preparation and time that has gone into this trial setting, which has been scheduled out for a long time, made by both the court and obviously the state in being prepared and ready to go, that there should be a presumption that we maintain the trial date. So the two concerns here raised in the motion really are, number one, the fact that Mr. Pryor would not be able to obtain payment for his services. And the court does strongly consider that because attorneys work for their profession and it's important that they get paid, and it's a consideration. But that in and of itself does not, in my mind, rise to the level of good cause under the rule 44.1 to grant the withdrawal. The second, and I think more concerning issue, is some indication in the motion of Mr. Pryor indicating that it would be very difficult, if not impossible, to be adequately prepared for trial. That's what's set forth in the motion. However, upon argument here today also, Mr. Pryor has indicated that he has made steps. I don't find anything in the record that he's been ineffective in his assistance of Mr. Daybell's defense in the case. And so with the concerns today being brought up and addressed directly by the court, both in open and closed proceedings, I don't find any specific grounds indicating that Mr. Pryor has said he cannot and would not be ready and prepared to adequately defend his client, although it may be difficult and he apparently will not be able to be compensated. It's not in the record that it can't be done. And importantly also, Mr. Daybell has affirmed today he does intend and would like to keep Mr. Pryor as his attorney in this case. And finally, I'll note that in addressing these concerns at that hearing a year ago, there was a representation by Mr. Pryor who said directly to this court, and I'll quote what was said in the hearing, quote, "There's going to be no continuance because I'm asking to get out of this case. That will not happen." And the courts relied all along on those representations in getting this case scheduled. So in balancing all that out and looking at whether or not good cause has been demonstrated today, I do not find that there is good cause for withdrawal of counsel. And so under Criminal Rule 44.1, upon consideration of that standard, the court is going to deny your motion to withdraw.
Okay, so motion was denied, but I want you to watch something here. The second that the judge left the courtroom, John Pryor, I'm going to go to the video. So I'm going to talk over the video. Watch screen right. John Pryor stood up and walked right over to the prosecutor and began chatting with them. Now, I did not hear what they said. I was in the courtroom, but a lot of you picked it up. The camera caught it. And a lot of people were saying, is he discussing a plea agreement? Is he discussing some sort of mediation? Mediation has been held in the past, but it's gotten nowhere. And Chad would need to admit to all three deaths, Tammy, JJ, and Tylee, for the prosecutor to be content with a plea agreement. And it would likely be life in prison without parole rather than the death penalty. So in just a couple of seconds here, you're going to see all the parties will stand, and then John will immediately go over to Lindsay and Rob, who he hadn't talked much with during the breaks or before the hearing, anything like that today. He will go over to them, and he's whispering something to Chad. Look at that. And then he goes over to Lindsay and Rob. Oh, and there it's full screen. You see them chatting. They muted the mic, so we couldn't hear what they were saying. But, you know, we don't know what they were saying. That camera stayed on for a little bit of time. What do you think? where they talk about a plea agreement. No plea agreement to report tonight. Could happen, though. Maybe John Pryor is going to say, okay, judge denied that. Let's do a plea agreement. Let's make that happen. So I wonder what your thoughts are about that. I want to give you a quick update on Lori Vallow. The judge or the attorneys down there and the judges granted filed a motion that it's a complex case. You might recall they originally set her trial date for April, same time as Chad's. That's not going to happen because the judge it's been deemed a complex case in Arizona. It will maybe happen end of this year, maybe early next year. But that's kind of about it for her as far as her trial down there. The appeal continues here in Idaho. It's quite possible. However, I should say the clerk filed a motion or filed a request to ask for a delay, or not a delay, but ask for more time to hand over the transcript. She's got to hand over the transcript of the whole trial to the appellate judges. So that's what's happening there. Not much new on Lori, but I do want to know your thoughts. Are people more interested in her trial or Chad's? I was the only reporter in the courtroom today. And I don't say that to brag, but it seems like every time there was a hearing on Lori, there'd be media, there'd be people coming. I'm going to continue to follow it regardless, but it's interesting that she seems to get more talk. It might be in the way she acts in the courtroom. She's smiling, she's laughing, flipping her hair. Chad is straightforward, straight ahead. Those are his thoughts. Okay, I want to take your questions. Our wonderful moderator, Peggy, has gathered a bunch of questions for me, and I'm just going to go through them. Mindy, Pryor says he isn't death penalty qualified to try this case since he's hired privately. Does the fact that he is or isn't death penalty qualified matter? Not because Chad hired him privately. You have the right as a citizen of the United States to hire whoever you want. I could hire a first-year lawyer if I was convicted of a crime and death penalty was sought on me. I could hire my buddy who's been out of law school for a year. But if I don't have the funds, if I'm indigent, then the court has to appoint me 2 attorneys. Both of them death penalty qualified. One is the main attorney, one is co-counsel. Jim Archibald was the main attorney for Lori. John Thomas was co-counsel for Lori. So the judge pointed out today that because Chad chose to hire this man, John Pryor, he doesn't have to be death penalty qualified. Can the death penalty be taken off the table now? Jennifer asks. No, unless a motion was filed for it, but the judge clearly did not do that, and the attorneys did not ask for that. Pryor's asked for it a couple times, 2 or 3 times, and the judge has denied it. As of today, death penalty is on the table. As part of a plea agreement, yeah, it could come off the table. Did you or anyone else hear Pryor scurry over to the prosecution team at the end of the hearing to ask about an agreement? Could he be asking for a deal? Amanda just asked that. Well, we talked about that. He very well could be asking for a deal, for a plea, for some sort of, okay, let's talk serious now. To be determined. We'll see. Who pays for the additional attorney that Pryor hopes to bring on? From Des. Hi, Des. The state would. That's what Boyce mentioned, that there could be some state funding that comes on to help assist with that. Because Chad is indigent, the state could cover it. Also, as far as Pryor not getting paid, Pryor has been paid. It's like, and I'm just making up a number, let's say that he was given a lump sum of $400,000. Well, let me back up. He was paid up front. So let's say he was paid $100,000 up front, or $150,000. I don't know if that's the case. But then he also took over possession of Chad's property. He now owns Chad's property. Let's say that property sells for $300,000, maybe $400,000. So let's say he's gotten $5,000 out of it. He's still getting paid, but obviously the hourly rate will go down because from here out, he doesn't have any more money. So he makes more money if he can settle it now or he's out of the case now versus working February, March, April, May, the next 4 months. So he'll get paid. It just won't be as much. And that's what That's what he'll have to deal with. So it's not like he's not getting $0. Also, you think about the fact that if he could have withdrawn from the case today, he can go back to Boise and take on 2 or 3 other smaller cases and make money from that. So he'll miss out on that money from taking other cases. But I will say John Thomas and Jim Archibald, they worked solely on Lori Vallow's case, I think from the day they were appointed. All the other stuff went to other attorneys. Tracy, where did all of Chad's money come from in the first place to hire private counsel? Well, you might recall Tammy Daybell left behind life insurance money. I don't remember the exact amount. Was it $400,000? So there was some money there. And I don't know if Chad had any in savings. The interesting thing is that because he's privately retained, we'll never know like exactly all the figures. We can request the information from the prosecutors or public defenders because you and I pay for them. And they have to provide that information. Private attorneys, not so much. If this is from life insurance funds, then is it an issue given the circumstances? Well, perhaps it could be. I don't know legally how that will all come from it. Chad Daybell, if he's found guilty, will be ordered to pay restitution. So he'll have to pay back the money to the life insurance companies. But realistically, is he ever going to get the money? No. And are they going to, they might possess his cars. They might possess any of his possessions that they don't have yet, but are they going to say account for every penny you took? Oh, John Pryor. I don't know how specific they'll get. Lindsay says, Nate, will you be doing Courtroom Insider during Chad's trial? Yes, I will. And I will be in Boise every day, except I have one of my best friends. He's getting married in Jamaica the 3rd or 4th week of the trial. And he's been planning it for a long time, for years, and I promised him I'm going to go, so I will be gone for a few days, the 3rd week. My wife and I are going to Jamaica. But the trial will be broadcast. We'll live stream it every day, so you can watch it, and then maybe I'll do a Courtroom Insider from Jamaica. Who knows? Diana says, so I understood correctly that where Pryor is hired privately, he does not have to be death penalty certified. Correct. Yep. Nate, do we need to take up a GoFundMe to provide caffeine for the judge? Pryor seems a bit of a handful. Pryor is a bit of a handful. This trial will be interesting to see his argument strategy versus Jim Archibald and John Thomas. They have different styles, but I will say, had Lori Vallow allowed her attorneys to be themselves and go all out, that would have been a different trial. I don't know if there would have been a different outcome. It would have been a different trial. Any idea how much money Chad's assets amount to? I don't. I mean, you could look up and find out how much his property's worth, but I don't think he has anything else really. If he has, it's probably been spent on this. I know they said in the trial of Lori that once Tammy died, I think he gave each of his kids $8,000 from the life insurance money and then had the rest. Hey, was Chad in shackles? He sure was. And one of the detectives, when Chad walked in, you heard the clank, 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 said, I love that sound. Amy said, because the judge denied a motion, can Chad file an appeal and win? Yes, he's going to appeal regardless, and that will probably be one of the things looked at. But I think the judge explained it well today in the fact that he said money really is not an issue, and the fact that you're not death penalty qualified, you don't have to be. You're privately retained. So yeah, it'll be talked about, but I don't know exactly, what if it'll get overturned. If it does get overturned on appeal, we have a whole new trial. So that could happen. All right. Well, I think that's all I have. Thank you for watching. Thank you for putting up with the technical difficulties. We will be in Boise for this trial and working on a couple of other possibility of shows and live streams and bringing you in. But for now, April 1st, we'll be there. We'll probably do a couple of these leading up to it. There are other hearings, by the way, between now and then. And anything's possible. There could be a plea agreement. And this trial might not happen. And Chad could go to away for life or something else. We'll just have to wait and see. Thank you so much for watching, for supporting us at EastIdahoNews.com. Here are the prompts to follow me. I have a Facebook page, I have an X page, I have an Instagram account, and I'm on YouTube. East Idaho News is on YouTube. We'd love it if you'd follow all those and you would stay in touch with us because we like doing that. All right. Thank you for watching. Hope you have a great night, and we will see you soon.